Hi there. Good morning, good afternoon, good evening, whatever time it is. As always, happy whatever day it is. This is the Erickson Report. I'm your host. My name is Larry Erickson. For the next half hour, we're going to be talking about some things that I hope you'll find interesting enough to stick with us. If you have any comments, questions, reactions to the show, you can always send them to me directly. My personal email is whoviating, WHOVIATING @AOL.com. So you can do that, or you can go to my website, which is called whoviating.blogspot.com, and do that there if you'd rather. But all right, we're going to start up today by following up on a few previous stories. The very first episode of the Erickson Report, we took a longer look at Venezuela and its disappearance as a news story after the U.S.-backed attempt to overthrow Venezuelan President Nicolas Maduro in favor of self-declared President Juan Guaido fizzled out. As part of that, I noted how the Tweety Pie White House had imposed 2 rounds of damaging economic sanctions against Venezuela, the first in 2017 and the second in January of this year. The follow-up is that on August 5th, there came a 3rd round of sanctions, these intended to be economically crippling to Venezuela. The executive order blocks all property and assets of the Venezuelan government and its officials, prohibits any transactions with them, including the country's central bank and the national oil company, essentially creating an economic wall between Venezuela and the United States. What's more, it threatens that any non-U.S. company that does business of any sort with any of these institutions with Venezuela could itself be subject to U.S. sanctions. In April, now, a study that was published by the Center for Economic and Policy Research found that U.S. sanctions against Venezuela had already resulted in some roughly 40,000 deaths between 2017 and 2018. And now, referring to this latest round of this economic terrorism, Michelle Bachelet, who is the United Nations High Commissioner for Human Rights, warned of the severe impact of the human rights on the human rights of the people of Venezuela of these sanctions, saying they could deny food, medicine, and other necessities to millions of people. The story may have disappeared from the U.S. media, but it remains real for the people of Venezuela who are being told by the U.S., in effect, give us the government we tell you to, or starve. Next up, a couple of weeks ago, I took a longer look at the Boycott, Divest, Sanctions, the BDS movement, and Israel, in the course of which I discussed the reports that Israeli snipers between the end of March 2018 and the end of December 2018 had killed 180 unarmed Palestinian protesters and wounded well over 6,000 more, figures which are both higher now. And referred to the fact that Gaza had been called the largest outdoor prison in the world. Here's an idea of what I meant by that. COGAT, C-O-G-A-T, COGAT stands for Coordination of Government Activities in the Territories. It is the Israeli government agency that scrutinizes every package coming into Gaza in search of banned items, including allegedly so-called dual-use items that could, Israel insists, be used for military purposes. Such dual-use items go well beyond the norm. The label can be arbitrarily put on such items as drones, cameras, and radios, for which you can at least imagine a military use, to things like microscopes, medical equipment, construction materials, and spare parts for assembly lines. And now COGAT has attained a real coup. The beginning of August, COGAT breathlessly tweeted that it uncovered, quoting, dozens of pairs of military shoes that were hidden in a shipment of civilian goods in an attempt to smuggle them into Gaza for terrorist purposes, adding that this is another miserable and failed attempt by terrorist groups in Gaza to hide behind the civilian population. The tweets were illustrated with pictures of the military shoes, this terrorist contraband. Yes, those shoes. That picture is taken from the tweet COGAT sent out. Pictures of ordinary, everyday, lace-up hiking boots. It was so absurd that a lot of people initially thought the tweet was a joke, but it wasn't. Instead, it is testimony to the deeply paranoid, deeply cruel, and deeply destructive blockade that Israel has placed around Gaza. It needs to stop. Finally, for this, around the end of July, I mentioned the argument being made against Medicare for all, against single-payer health coverage, claiming that polls say that people love their private insurance plans, so that anything that proposes getting rid of those is doomed to failure. Well, here's the thing. At the time, this is what I asked. At the time, and quoting myself here, are those people really happy with their insurance? Are they happy with the premium, the co-pays, the deductibles, the medically necessary procedures put on hold until you see if insurance will cover it, the inability to choose your own doctor because they are out of network? Or are they just happy that they have insurance? Well, a recent Business Insider poll appears to answer that question. It showed that 59% of those who have employer-provided health insurance say they would support switching that insurance to a government plan under Medicare for all, as long as the coverage was just as good or better, which it would have to be, otherwise there's no point in doing Medicare for all. The results, Business Insider said, highlight the fact that mainly people just like being covered, bearing little loyalty to any specific provider. Incidentally, that same poll also found that among those Americans on government-run health programs, Medicare, Medicaid, and military programs, 57% of those people love their plan. That is 16 percentage points higher than those with employer-provided insurance and 18 points higher than those with privately purchased plans. All right, switching now to a regular feature. It's 2 weeks of stupid, clowns and outrages. And we start as usual with our clowns, and we got a bunch of them this time. Our first clown is conservative radio host and poster boy for privilege, Ben Shapiro, who said on his show a couple of weeks ago that people who have to work 2 jobs are just basically, well, stupid. Quoting him, if you had to work more than 1 job to have a roof over your head or food on the table, you probably shouldn't have taken the job that didn't pay you enough. That'd be a you problem. Put another way, if you have to take a 2nd or a 3rd or a 4th or whatever job in order to provide for your family, it's your own damn fault, because what you should have done is refuse to take any job at all until one that paid enough came along. He got scorched on Twitter, provoking him to shift into damage control mode, claiming, and I'm sure I don't have to tell you this, but he claimed he was taken out of context. The context being, it seems, that government should not take any steps to try to support a living wage because the market, PBUI, knows more than you do, he intoned. Now, how that affects his blaming struggling people for the problems they have goes unexplained, which actually is pretty standard procedure for a clown. Oh, next up, and we're sort of taking these chronologically, next up comes the Hasbro Company, which has come out with a variation on the board game Monopoly, this one called Monopoly Socialism. You immediately can get a flavor of the game by noting the tagline is, "Winning is for capitalists." Historian Nick Caper described the game in a lengthy Twitter thread, and he included the lame jokes it has about vegetarianism and how that got to be part of socialism. I don't understand. There are lame jokes about the "we are all winners" school. And he also noted that among things came in for mockery were environmentalism and voting. The whole idea seems to be that no one in the game gets anywhere. The community fund that finances projects that individuals can't afford is designed to be repeatedly going broke. And from time to time, any wealth the community actually does accumulate is simply destroyed. Now, I could have done without Caper's suggesting the target audience for the game is, and I'm quoting him, hate-filled baby boomers who grew up during the Cold War and are triggered by anything done by anyone under 40. But the fact remains that this whole game is so laughably lame that I honestly can't imagine who it is for, and it is clearly the product of the minds of clowns. All right, next up. In response to a recent report that bed bugs had been found in the newsroom of the New York Times, a George Washington University professor named David Karpf tweeted that the bed bugs are a metaphor. The bed bugs are Bret Stephens. Stephens being a right-wing Times op-ed columnist. His tweet got, Karp said later, 9 likes and 0 retweets and was not sent to Stevens. Now, personally, I think the joke isn't funny and maybe even a little bit creepy, but Stevens, who somehow heard about it, went out of his freaking mind. He wrote to Karp complaining about the tweet and essentially daring Karp to come to his house and say it to his face, a letter which he copied to the university provost, that is, Karp's boss. Oh no, not to threaten his job or get him in trouble at work or anything like that. Oh no, of course not, perished the thought. No, it was simply he thought that the provost should be informed of his underlings' activities. He then wrote a whole column about attacks on Jews during World War II, referencing insect comparisons and saying the rhetoric of infestation is back. He then took advantage of his place as a contributor on MSNBC to get some FaceTime bloviating about his side of his then bi-viral spat with Karp, an opportunity which Karp, by the way, was not offered. And if all of that doesn't add up to clown status with the Times and MSNBC as enablers, consider this. Despite CCing Karp's bosses, in the case of Tucker Carlson saying Iraqis are semi-literate primitive monkeys, Stevens defended him, saying that threatening somebody's job or career is an assault on free speech. Plus the fact that insect references, infestation references, are not new to him, considering he once called Palestinians one giant mosquito. Okay, an old favorite clown, Senator James Inhofe. He has introduced an amendment to the National Defense Reauthorization Act to limit the authority of the Federal Emergency Regulatory Commission to regulate lake levels and flood control related to a dam on Grand Lake in northeastern Oklahoma. Folks upstream of the dam, including Native American tribes and people in the poverty-stricken town of Miami, say that maintaining high water levels in the lake contributes to floods around their homes. In fact, there have been 24 floods in less than 30 years, resulting in 150 homes being torn down, many more abandoned. This spring's flood caused the Eastern Shawnee tribe to have to evacuate with their ceremonial grounds covered in 3 feet of water. Inhofe wants higher levels at Grand Lake on the grounds that it, and this is a quote, makes the lake a better place for recreation and commerce. Of course, we around here are all quite sure that the facts that he has a vacation home at the lake and there is a company in his wife's name that holds $1 million in property around the lake have nothing to do with his enthusiasm for deregulation. Inhofe's middle name, by the way, no joke, is Mountain, which seems entirely appropriate for a clown with rocks in his head. Oh yeah, and Lord, the clowns keep on coming. LeBron James has reportedly filed a trademark for the phrase Taco Tuesday, apparently based on his popular series of social media posts on it. According to the application, James wants to trademark the phrase for advertising and marketing services through indirect methods that include social media and blogging. So be careful. If you ever want tacos on a Tuesday, you may wind up having to pay a fee to LeBron James. Now, as a footnote to that, of course, the phrase Taco Tuesday has been around for some time, long before LeBron James became a fabulously rich man who wants to be a fabulously richer man. The thing is, you're not supposed to be able to trademark a common phrase or expression. But in a world where money speaks louder than law and the patent office is hopelessly overburdened, that principle did not keep Paris Hilton from trademarking "That's hot," nor did it keep Rachel Zoe from getting a trademark on the word bananas as describing something crazy, even though that's an expression that's been around since at least 1935. Okay, then there is the administration of the Highland Hills Middle School in Highland Hills, Indiana. A 13-year-old girl got in trouble there over a T-shirt. What was wrong with it? Well, it had a slogan that read, "Why be racist, sexist, homophobic, or transphobic when you can just be quiet?" A shirt which the principal declared inappropriate and disrespectful, along with claiming the words sex and homo are too eye-catching. As you can see in the picture, yeah, they just really pop out at you, don't they? The school's dress code bans shirts that are suggestive, obscene, or promote alcohol or drug products or use, or which are sheer. It seems that oppose bigotry should be added to that list, unless doing so is already considered obscene. Finally, for this time, we have the Reverend Daniel Rehill, a pastor at the St. Edward School, which is a Roman Catholic grammar school in Nashville, Tennessee. He just sent an email to parents of students telling them that the Harry Potter books have been removed from the school library because they risk conjuring evil spirits. Seriously. Quoting the email, quote, "These books present magic as both good and evil, which is not true, but in fact a clever deception. The curses and spells used in the books are actual curses and spells, which when read by a human being risk conjuring evil spirits into the presence of the person reading the text." Which personally I think is just ridiculous. Clowns to the right of me, clowns to the left of me, clowns in front of me, volleyed and thundered. Let's take a break. And we are back, and we are going to our outrages, and what we have here is two linked outrages, which in fact in turn lead right into a longer look. Our outrages are linked by the way they demonstrate a profound flaw, a profound failing at the heart of our criminal justice system. And I'm not talking about racism or classism, which is the advantage that rich people have over everybody else. I'm talking about the philosophy that undergirds the system itself. Our first outrage involves one Larry Swearingen, who on August 21st was legally murdered by the state of Texas. Swearingen had been convicted in 2000 of the 1998 rape and murder of 19-year-old Miss Trotter. The evidence was strictly circumstantial, consisting largely of the fact that he was the last person seen with her before she disappeared, and some signs of what could have been a struggle in his home. No physical evidence connected him to the crime. The closest thing to actual hard evidence was the fact that a cell tower picked up his cell phone signal, which could have placed him on a road that was relevant to the case at that time. Swearingen never denied knowing Trotter and maintained his innocence literally to his last breath. His attorneys had mounted a major effort through the legal system to defend him, actually fending off 4 previous states for execution, arguing the prosecution relied on junk science. All right, so what's the deal here? It's that a number of influential Texas pathologists, together responsible for thousands of death investigations every year, say the evidence proves that Trotter had not been dead very long when her body was found more than 3 weeks after she disappeared. In which case, Swearingen could not have killed her because, ultimate alibi, he was in prison on an outstanding warrant, having been arrested just a couple of days after Trotter vanished. Even the medical examiner who conducted the autopsy, one Dr. Joy Carter, recanted her trial testimony in 2007, admitting that the ease with which she was able to weigh and dissect Trotter's organs, which would have been seriously deteriorated had she actually been killed in the time frame before Swearingen was arrested, made the state's timeline impossible. Here's the crucial point: the courts didn't care. As an example, a 9-day hearing was held in 2012, laying out expert testimony on why Trotter had to have been killed not long before her body was found, thus long after Swearingen was in prison. Even before the final transcripts in that hearing were filed, Judge Fred Edwards, who presided over the original trial, dismissed the science as junk. And so it went. The appeals were made, the rulings were issued, the procedures were followed. There was no error in the operation of the machinery of the law. All the I's were dotted and the T's crossed according to formula. And so finally, Swearingen was officially killed and the law was satisfied as a very likely innocent man lay dead. Our second outrage involves Lamar Johnson, who has been in prison for Missouri for 24 years, having been sentenced to life without parole for a murder even prosecutors now say he did not commit. Johnson was convicted of murdering Marcus Boyd in 1994 in a case that even at the time should have made people scratch their heads. Prosecutors claimed that in the space of 5 minutes, Johnson left a friend's apartment, traveled 3 miles to Boyd's home, killed him, and then traveled by foot back to his friend's apartment. But what's brought renewed attention to the case is the fact that St. Louis Circuit Attorney Kimberly Gardner's Conviction Integrity Unit has filed a 67-page motion seeking a new trial for Johnson based on having uncovered a staggering amount of misconduct on the part of homicide detectives and prosecutors, including inventing witness statements, paying the single eyewitness, and pressuring that witness to make a false identification. Then there is the fact that 2 other men have confessed to being the killers, one in 1996 and one in 2002, saying that they were the ones who together wound up killing Boyd in a botched robbery. But Circuit Judge Elizabeth Hogan rejected that motion on August 23rd, saying in effect it was 24 years too late, citing a provision of Missouri law that, believe it or not, requires a motion for a new trial to be made within 25 days of the end of the trial. And Hogan's decision gives no hint of there being an exception for evidence uncovered after that time. In fact, in her ruling, Judge Hogan seemed much more concerned with the question of if prosecutors and Johnson's lawyers had violated some rules of court procedure in pressing for the new trial. She wrote that she was, and I'm quoting, concerned about the integrity of the legal process in this case, even as she could not spare a word for what one of Johnson's lawyers called the clear, convincing, and overwhelming evidence of Johnson's innocence. She did, however, for some reason, find it relevant as part of the background of the case to note that the same day that Gardner filed her motion, she also, quoting, released a copy of the motion and exhibits to the national media, which bluntly doesn't say a whole lot for Hogan's impartiality in this matter. And so Johnson still sits in prison, hoping against hope for a successful appeal, although it's hard to see on what basis if Judge Hogan cited that law about filing for a new trial correctly, since there's no visible error. Even if the aside about releasing the motion to the media is taken as an indication of personal bias against Gardner or her office, that error would be seen as not important enough. And here we now turn to a longer look, because it brings up, these things bring up what it is that unites the cases beyond the fact that they're both about murder. It serves to point up the profound failing, again, at the heart of our legal system. Swearingen was legally murdered because there was no error in the procedure. There was no misstep in applying the rules of the courts, and there's no requirement for a court to consider new evidence. Johnson is still in prison because the court system was more interested in the integrity of the legal process than the fact of a wrongful conviction. The court system, that is, the courts as part of what we call the criminal justice system, the court system is more interested in the technicalities of legal procedure than it is with truth or justice. It's been said before that the law is not about justice. The law is about the law. And despite what we call it, we do not have a criminal justice system. We have a criminal law system. So what happened in these cases is not the fault of Judge Edwards. It's not the fault of Judge Hogan. It's the way the system is designed. The original trial court is the only place where matters of facts are to be determined. After that, any higher court, it's all about procedure. It's all about rules and regulations, and the truth of the original charge, even the personhood of the convicted, just fades to insignificance. Now, certainly if you can show corruption on the part of police or prosecutors, you can get a conviction overturned, but that's because they broke the rules, not because of any justice or injustice of a wrongful conviction or anything to do with the truth of the original charge. The profound flaw at the heart of our criminal justice, our properly called criminal law system, is that it equates justice with the process, not with truth or fairness or decency or even the accuracy of the charges, and sees nothing wrong with innocent people being imprisoned or even executed as long as they got a fair trial. To be convicted, the evidence has to show guilt beyond a reasonable doubt. But if you are convicted, the system is designed to assume that result is correct. So in the absence of some demonstration of official misconduct, of rule breaking, getting reconsideration on the basis of new evidence is like trying to change the mind of someone who has already firmly made their mind up about something. It happens, yes, but it's rare. The system that claimed a bias in favor of the defendant at trial now has a much stronger bias in favor of the prosecution. It goes so far that the Supreme Court has never actually found it unconstitutional to execute a person known to be innocent of a capital crime, not so long as all the correct procedures are followed. For example, in the 1993 case, Herrera v. Collins, the Supreme Court denied habeas relief to a Texas death row inmate, ruling that on the absence of other constitutional grounds, newly discovered evidence of actual innocence would have to meet a, quote, extraordinarily high, unquote, threshold to be grounds for a new trial. They said his didn't. He was later executed. The only sliver of hope on this particular front is found in the case of Troy Davis, another possibly innocent man executed by the state, in this case Georgia, in 2011. Responding to a 2009 petition from Davis, the Supreme Court ruled that the district court should receive testimony and make findings of facts as to whether or not evidence that could not have been obtained at the time of trial clearly establishes petitioner's innocence. Now, that clearly is an extraordinarily high standard. It requires evidence that could not was not, but could not have been available at the time of trial, and that clearly establishes innocent, not establishes reasonable doubt about the verdict. But at least it suggests, although it does not say, that it would be unconstitutional to officially murder someone, even if all the legalities are seen to. But the devotion to procedure rather than justice remains. I don't have an answer for this. I don't have a proposal for change. I admit in fairness that a lot of the incantation-encrusted structure that has grown up around the law arose from attempts to prevent personal biases and cruel arbitrariness from determining the outcome of legal proceedings. But in so doing, it has mostly locked out concepts such as compassion and completely rejected the concept that sometimes it's necessary to slip outside the rules to do something right. Meanwhile, as our legal system has become a nearly impenetrable, self-referential high priesthood, where most of us can find ourselves blocked from the courthouse for not knowing which official form to file, or for not knowing a deadline, because it was up to us to know, that failing continues to eat away at the justice which we foolishly believed was the whole point of the system. And the names like Larry Swearingen, Lamar Johnson, Troy Davis, like others wrongly convicted, even wrongly executed, will continue to haunt us. Again, I don't know the answer, but I do know this. At his legal murder, Larry Swearingen said, "Lord, forgive them, they don't know what they're doing." I think he was wrong. I think they know exactly what they are doing. They are serving the system. All right, I'm going to have to wrap it up there, so we're going to stop right there, just about out of time. So for now, I'll just say that hope you keep watching. Hope you enjoyed. Again, if you have any comments, feel free to email me with them, huvi@aol.com. But for now, as always, peace.